So my name is Meg Sheehan. Thank you for coming today. This is our Wetlands Forum to provide education and education to local people, and our goal is to help people understand how the state protect that and the local wetland bylaw to protect our water, our forests, and our wildlife. And we're here today. Neil Andy Stevens. I'm from Community Land and Water Coalition. You can check us out on savethepine-barrens.org. You can join our mailing list. We keep people up to date about what's happening. We're a coalition, a network of groups and individuals in southeastern Mass, and our primary goal is to protect our groundwater aquifer. We were formed about a year and a half ago in response to the rapid development that was happening in the region around groundwater projects and gravel mining and other projects that we felt people need to be informed about and have information about what they do. So much of what happens in Massachusetts around land development is happening at the local level at our planning boards, our zoning boards of appeals, and our conservation commissions. So since the Wetlands Protection Act and our town bylaw are really, those are two of the strongest laws that we have in Massachusetts to protect our water, and it has a lot of opportunities for the public to get involved. We wanted to give an overview of how you can get involved and what we're talking about and what you can do. So we'll be here for about an hour talk, and then we'll have a Q&A, and always happy to stay in touch. So I'll introduce Nathaniel, and here we go.
Thanks, Meg. Thanks. Good afternoon, everyone.
Oh, I will just say that we do have some handouts. A few of them are printed here, but we have also uploaded them to our website where this event is listed. So you should be able to get those, and we also have information such as the town wetlands bylaw and those regulations.
Yes, welcome. Have a seat.
Excuse me for a minute.
Sure.
I'm not sure if you all are seeing in the chat, but the big echo in that room. So you need to get really close to your microphone.
Okay, thanks.
Here's the microphone. Is this better?
Is this better?
Yes.
Okay, great. It's right next to me, so I'll try not to knock it over. Thanks. Good afternoon. Before I dive in, I just wanted to get an idea of who is in the audience today, and I guess on a raise your hand basis, we don't have time to go around the room, everyone on Zoom. If you could raise your hand if you are presently on or have served on a conservation commission. Okay. Have you worked for a conservation commission as an agent or administrator? Yeah, for the first question. Okay. Been on. Okay. Has anyone attended a conservation commission? Right. And the rest of you here probably have no idea what a conservation commission is. Or you're here for another reason. Great. Good. Well, welcome. Well, thanks. This afternoon, this is what the topics we hope to go over. Just a brief refresher on what some basic background, so we all have the context about what laws and rules and regulations and policies are. We'll talk about Conservation Commission duties and responsibilities. We'll delve into one of those responsibilities in more detail, which is the purpose of this afternoon's forum, and discuss the Wetlands Protection Act and the Plymouth Wetlands Bylaw. Specifically, what is a wetland resource area? We say wetland resource area. What does that mean exactly? We have examples. What's the wetland permitting process and jurisdiction of a conservation commission? And then there are several topics related to wetlands permitting that overlap that are important to cover: stormwater, and then enforcement of the wetland laws that we have on the books. Also related to wetlands permitting is endangered species, and that ties into the Massachusetts Endangered Species Act. If we have time, we will discuss the other related Plymouth boards and commissions and officials who have some either role or administer laws that are related to wetlands and the water resources in the town. And then we will have, as Meg said, we shall have plenty of time for questions and discussions. Again, the purpose here is to get you familiarize yourself or get a deeper understanding of the laws in Plymouth that the Conservation Commission administers and how they do that in order to protect the wetlands and water bodies. And this includes the Plymouth Carver Sole Source Aquifer, which it has been designated by the US EPA under the Safe Drinking Water Act. And it serves 7 towns, so it's quite important, and also provides some drinking water to the town of city of Brockton. Over 150,000 people depend on, at least 150,000 people depend on this aquifer for their water supply. But as you know, there's the high groundwater in Plymouth, and the ponds in Plymouth are all part of this aquifer system.
Stay close to the mic.
Oh, so even closer to this. Okay, I will try to. Can we point it? Wait, we'll turn this way towards me. Okay, that might help. Is that helpful? I guess let me know, Meg, on that. And this Meg asked me to mention that this forum builds on a prior one that she did about a year ago, June of 2021, called the Community Planning for Conservation. That webinar is available on YouTube, and the link is available right there. So just a quick review, some civics lessons for everyone, just to remember that what the differences are between laws, regulations, and policies in general, an overview. A law, as you know, tells people to do something or not to do something, or it sets standards and goals. At the state and federal level, so on Beacon Hill at the state level and on Capitol Hill at the federal level, they enact statutes and laws. Laws and statutes, same thing. In Massachusetts, cities and towns have the ability to enact their own legislation, and they have their own legislatures. In cities, that's generally the city council. In towns, that's generally the town meeting, which, as you may know, meets at least once a year annually, and sometimes special town meetings. In towns and bylaws, it's important to distinguish. There's 2 types of bylaws. There are zoning bylaws. You probably know what zoning is. It regulates how you can use property, and where buildings and how big buildings can be on property. And then pretty much everything else is a general bylaw. The Plymouth has its own wetlands bylaw, like about half of the municipalities in Massachusetts, and that is a general bylaw. When general bylaws are passed by town meeting, they are reviewed by the Attorney General's office and then become law, assuming the Attorney General approves them. I'm not sure what the batting average is for that, but generally most town meeting bylaws are approved by the Attorney General. And then we rely on the courts to help us interpret what these bylaws mean, what these statutes mean, what these federal statutes mean. So the courts are helpful in that regard. Statutes and bylaws give certain authorities, the people who are implementing the law, the ability to pass regulations. And so what are regulations? They are really the details that help carry out the purpose of the law or the bylaw. They provide more details on the procedures or the standards or the goals, how to achieve a goal that's set forth in legislation. They also, if needed, they provide clarification. Often the legislature is not the model of clarity when they write something, so things can be interpreted in many ways. So the person who's in charge with carrying out that bylaw or statute, often through regulations, provides clarity on a substantive matter or even a procedural matter. And regulations are often quite detailed and have procedures about how to apply for something and also meet other requirements. Again, the statute or bylaw specifies who is the one who can enact regulations. It's not just anyone. In Plymouth, for instance, your wetlands bylaw says that the Conservation Commission has the authority to issue rules and regulations. It's not town meeting. It's not the Board of Selectmen. It's not anyone else in town. It's the Conservation Commission. As is often the case in these situations, there are provisions for public notice and public hearing on that. And some important parameters about regulations. They can't expand or exceed the authority of the bylaw. So if the bylaw says that the commission has jurisdiction over a certain area, the regulations can't say there's more. So the regulations have to fall within the scope of the bylaw or the law. Some conservation commissions, I'm not sure that Plymouth does, they have policies, And policies, the main difference there is a policy is not enforceable as a matter of law. Regulations are enforceable, they legal import. Policies are easier, are more informal, less formal procedure, and they are helpful in some instances in interpreting regulations. So diving into wetlands laws themselves, and again, more focused on that, just at the federal level, we have wetlands laws. A portion of the Clean Water Act called Section 404 touches on and really affects work in wetlands and aquatic habitats. There's also the Rivers and Harbors Act of 1899. And these are both administered by the U.S. Environmental Protection Agency, as well as the U.S. Army Corps of Engineers. They each have very detailed regulations, very, very detailed. At the state level, we have the Wetlands Protection Act that was enacted. The first portion of it was enacted in the early 60s for coastal wetlands, and then a few years later for inland wetlands. This act is, as it says, is administered by the Department of Environmental Protection, although also also in conjunction with conservation commissions, because the conservation commissions are the forefront when you apply, as we'll discuss later. That's where the application first goes. It may end up at DEP, but it first starts at the Conservation Commission. But ultimately, DEP is the one who is ultimately responsible for administering it, and therefore they're also the ones who have the authority to issue regulations, which they have. And again, at the municipal and town level, as I've alluded to, we have the Plymouth Wetlands Protection Bylaw. This, I'm not sure when this was passed, Meg may know, but maybe 20, 30 years ago, at least, I think, looking at it. And this is administered by the Conservation Commission. And they have, as I mentioned before, they have the authority to issue rules and regulations, which they did in 2010. And then I think in 2022, although I understand that those have recently been changed. In order to have an effective bylaw or an effective rules and regulations under your bylaw, it's important that the provisions be stricter than those that DEP has under the Wetlands Protection Act. And again, we have the courts and administrative law judges at DEP who help us interpret all the provisions of the Wetlands Protection Act and the Plymouth bylaw. As you may know, the Conservation Commission is comprised, there are 7 volunteer members. They're not paid. They volunteer their time to go to evening meetings once or more times a month. They go on site visits, they do homework, they review applications outside of the meeting. And I say that as a Conservation Commission myself in my town, so I'm somewhat familiar with the workload. And Plymouth is very fortunate. Not every municipality actually has paid staff to support the Conservation Commission. Many of the communities out in the western part of the state, it's up to the chair to interact with the public, receive the applications, deposit the application fees, do all that work. So Plymouth is lucky to have a conservation planner, as well as apparently an administrator to help out. And Meg asked me just to clarify that it's the Department of Environment and Marine Affairs is not the one who administers the Wetlands Protection Act. I think there's some confusion. It's easy to think with that name, Department of Environment and Marine Affairs. There's overlap. Conceptually, one could think that it's the wetlands laws are being, and the wetlands bylaws being administered by that department, and that department is made up of the harbor master and the animal control officer. And apparently it also has the natural resources division, which I believe helps manage some of the conservation land, which the Conservation Commission actually technically owns. It's in their name. So just to hopefully clarify that. Again, the primary duties of the Conservation Commission for wetlands permitting are the Massachusetts Wetlands Protection Act. There's the citation there, and the DEP regulations, as well as the Plymouth Wetlands Protection Bylaw. These are often administered together, not one after the other, but if someone files an application under both, the hearing and things like that are all processed at about the same time. Conservation commissions also do have other duties in other towns. They have, I think, more duties because Plymouth seems to have divided up some, for instance, updating the open space and recreation plan often is a duty of the Conservation Commission. I believe there's an open space committee here who does that work for the Conservation Commission. But the Conservation Commission here is, as I said before, manages or is a steward, is the owner of the conservation land. So they have that responsibility. So often commission members need to remember which hat they're wearing when they're doing whichever duty it is. The purpose of the Wetlands Protection Bylaw is to protect and preserve certain areas, which are the shores, rivers, wetlands, and other water bodies and related resources in the town. And how do they do this? They do this by controlling the activities, any activity which the commission deems will have a significant or cumulative impact on the wetlands functions and values. So these wetlands functions and values are often described as interests. They're not economic values, although they're ecological values, which some people do measure in terms of economic values, but they're the ecological functions and values in the Wetlands Protection Act are often referred to as interests, just all the same meaning. And here, if you can see the slide, are the eight interests of the Wetlands Protection Act. We have the of most, I think, importance in Plymouth is public and private water supply and groundwater supply and flood control. There's also storm damage prevention, prevention of pollution, land containing shellfish, fisheries themselves, and wildlife habitat. Importantly, not wildlife, but wildlife habitat. The Plymouth bylaw, like many bylaws in Massachusetts and many local wetlands ordinances, have additional interests and functions that are protected in these resource areas. So what is a resource area? What is a wetland? Is it just a swamp, a bog, a marshy area that we think of in cartoons that we saw growing up or illustrated in these pictures? It's more than that. It's a broader term. And generally they're divided into coastal wetlands resource areas and inland wetland resource areas. And that really just comes from how the DEP regulations were evolved. We first had regulations for coastal wetland resource areas and then inland resource areas. I'm going to describe them a little bit backwards. And this slide, which is a cross section of a stream. The blue at the bottom of the image there is a water body. Hopefully you can see it clearly, which is here in this instance is a stream. And next to that, there are banks. So a bank is a resource area, the bank of the stream. Also, the resource area is the land under, it says land under water body below that blue writing, and that is of itself a wetland resource area. So that has standards that have to be met. Moving to the right, no, screen right, is a bordering vegetated wetland, which often are next to streams, often next to lakes, often next to water bodies. That itself has a 100-foot buffer zone area, which there's a important difference between that and the buffer zone under the state act compared to under the bylaw, which we'll discuss in a moment. In addition,
sorry, just a second.
Sure.
This definition of these elements of the resource area in the Plymouth bylaw or in the wetlands, this state wetlands protection act?
This one is under both. I think it's covered under both. So there are identical resource areas under the local bylaw as there are under the state bylaw. And then the local bylaw actually has some additional resource areas, which there's a comparison chart coming up on another slide. Sure, no, good question. Thank you. And then, so then you can see the yellow line, squiggly line above the water body that says 100-year floodplain. So the FEMA 100-year floodplain is protected. That's a resource area. So any work within that. And the lingo for that goes by the acronym BLSF, which is bordering land subject to flooding. So it's the floodplain that borders a water body. And that's to be distinguished from the resource area that you see in the far right between the trees, which says isolated land subject to flooding. So there are some areas that aren't bordering a water body that are still protected. And the DEP defines them. I think it has to hold a 1/4 acre-foot of water. So it's a certain size. It's not just any puddle, not that puddle out in the parking lot, but certain sizes as a practical size that meets the definition. And I believe that your bylaw has the same thing. For resource, there's another important resource area here for streams that are perennial, that run throughout the year. Those are called rivers, and those have a 200-foot riverfront area. So significant resource area. So from the bank, from the top of the bank all the way upland into the woods, 200-foot riverfront area. That was added in 1996, so that's relatively new. 1996, we like to think is not that long ago. And I think those are, let's see, oh, I should mention that for the buffer zone I mentioned before, so there's a 100-foot buffer zone to certain, not all the resource areas. And for DEP, their concern is, does any proposed work in that buffer zone, is it going to alter the resource area that is adjacent to? So they don't care as much what's happening per se in that buffer zone, but they're concerned about, okay, how is it going to affect the wetland next to it? Your bylaw is different, like many bylaws, and they actually say, well, we treat the buffer zone as its own resource area, kind of like the riverfront area. We're going to examine what's happening in it. We have standards in it. For instance, the first 35 feet of that 100 feet is called the no touch zone. From 35 to 50 feet is a no build zone. And from the remainder from 50 feet to 100 under your local bylaw regulations say that work can only be in there if there's after you pass an alternatives analysis to prove that the work can't be beyond 100 feet. So that's an important jurisdictional difference. And okay, I've covered all the resource areas there. Okay, switching over to coastal resource areas. There's two sketches here that cover the different resource areas. The one we'll start with the one on the left of the screen, and this again is a cross section of one type of shoreline you might experience. And moving from the right side of the image, going to the left, we have again land under water body, land under ocean, like we do in the inland wetlands. Here, there's a tidal flat between the low and the high tide line, and that's tidal flat or coastal beach. And then adjacent to that is the salt marsh. This diagram has more details, more ecological details, really, than regulatory details about a high marsh and a low marsh there. But the salt marsh is actually has one of the highest levels of protection under the DEP regulations, which is worth noting. On the image on the right, you'll see that's another scene, more of a diagram drawing of a coastal beach area. Again, land under the ocean, land under water body. That's on the far right. Then you have a coastal beach, which includes the tidal flat, and then landward of the coastal beach is typically a coastal dune or a coastal bank, and those are also protected as well. It's important to realize that there can be overlapping resource areas, and this can be a lot of fun when you're trying to figure out what's going on. So this is an example here. On the left side of the image, we have a stream, and it's a perennial stream, so it's a river. And you'll see at the bottom of the screen, it says 200-foot riverfront area. So within that, we also have other resource areas. Right next to the stream is bordering vegetated wetland. And also there's floodplain, 100-year floodplain. And then the bordering vegetated wetland, that's one of the resource areas that has a buffer zone, and that has the 100-foot buffer zone to it. So here is a list. You were asking earlier about you're asking about the different resource areas, and this is a comparison for the inland resource areas of what the Wetlands Protection Act covers compared to what the bylaw covers. And here, for instance, a significant difference is the Wetlands Protection Act, again, only covers wetlands, vegetated wetlands that border a water body, whereas your bylaw actually covers isolated vegetated wetlands as well. So that's an important difference. And they call them isolated vegetated wetlands and then unvegetated wetlands as well. Also, the creeks and streams themselves, not just the land under them, apparently are protected, but also the water in them as well. And vernal pool, that's something that local bylaws often regulate. The Wetlands Protection Act does protect wetland pools to a degree, but only if they fall within another existing resource area. If it's within a BVW, it's protected under the state act. But if it's not, if it's sitting by itself, 100 feet, 200 feet away, no protection under the state law. Under your bylaw, however, that's a separate resource area, so that is protected. We will come to that in a bit. Yep, thanks. Yep, we will touch on that. Good question. Under coastal resource areas, I didn't see as big as many additional resource areas, but certainly just because there are two additional ones, they're not any less significant. We have an estuary that's protected in and of itself. And then salt ponds and their buffer zones are also protected. So how do we protect these resource areas? And through what the law says. And the law says that no person shall remove, fill, dredge, alter any resource area without first applying to and getting permission from the Conservation Commission. The top paragraph is the language from the Wetlands Protection Act, the State Act, and the lower paragraph is almost identical language from the Plymouth Wetlands bylaw. Sure.
That you're quoting from, the ones that they just rescinded, the ones that were passed.
No, there's no change to the bylaw. It's for the
No,
bylaw.
yeah, not change of the bylaw. This is the bylaw, yeah. So, right. No worries, no, it's easy to confuse. So, yeah, so this is still the same. So town meeting would have to change the language of the bylaw. No, the Conservation Commission would not have the authority to do that. And again, so you need a permit if you're doing work you're doing work. So this is what type of work? Really land disturbing activities. This is the best way to do it. If you is dredging and altering. Altering is a very broad term, but and there is some gray areas. You know, if someone walks through a wetland area once a month, probably no harm. But if 100 people walk through it every day, well, that might be a path. That might be more of an alteration. So someone needs to get permission if they're doing work within the jurisdictional area, within one of those wetland resource areas we just reviewed, and that work will in fact have an impact, will alter the wetlands. It's important to know that activities outside of the resource areas are not subject to regulation. You don't have to get a permit if you're, say, 300 feet from a wetland. However, if that work ends up altering, let's say there's drainage coming from a wall of that work area and ending up in a wetland, then the Conservation Commission has authority. We call that after the fact jurisdiction, after the fact of the work having occurred, rather than the reverse where you're reviewing proposed work. There's a small slight exception to this and this rule. And that's if there's a discharge pipe, say, into the buffer zone or right near a wetland, a Conservation Commission has some limited authority to look what's happening outside of their jurisdiction. This is often the case with a subdivision. The developer has a subdivision road and they need drainage and they have a pipe that comes right within 100 feet of a stream or something. And in conjunction with a bridge crossing a wetland or a stream, that the commission is reviewing that. And usually if that pipe wasn't there, the commission would really not have any authority to look outside and beyond their jurisdiction. But in this case, they do have the authority to say, okay, well, what's happening? What are the roadways like outside the jurisdiction? How much drainage is coming through? There are, of course, some exemptions. These are in the statute, and some are also in DEP's regulations. There are minor projects. DEP has decided that over the years, in their experience, they found that certain activities, minor projects, are exempt from a review. If you're installing a fence, provided the fence is a certain design, a conversion of impervious to pervious surfaces. We like pervious surfaces because they allow the rain to flow through, whereas impervious surfaces just make the water run off. Also, planting of native trees is encouraged, and they found that actually helps resource areas and not harms them. There's also provision for temporary activities such as site investigations, if you're installing a monitoring well or something minor like that. There's exemptions for underground utilities if they're done exclusively within a roadway or driveway. There's also exemptions and statutory exemption for agricultural activities. Generally, it's for the maintenance of land in agricultural use. And the important thing is that this is for existing agricultural activities. If someone wants to plant, they've bought a nice piece of property and it has wetlands on it, and they decide they want to do agriculture, they're not exempt. They have to apply because that's not land presently in agricultural use. And there's a DEP does have an extensive manual on farming in wetlands, and that's a good resource for when that issue comes up. Also, agricultural does include certain forestry practices as well. Certain public utility projects are exempt from regulation, as is the application of herbicides on rights of way, provided they're done under state approved plans. So in general, the wetlands permitting process, again, applying for a permit, one has to determine that you're within the jurisdiction of the Conservation Commission. An application is filed. In a minute, we'll go over the different applications types. Oh, okay. I'm not sure. Anyone? Can they hear us on Zoom? Is the internet?
Yes, we can still hear you.
Okay,
Yes.
can you see the PowerPoint?
Yes, we
Yes.
can.
Oh, okay.
So we're still seeing the permitting process slide.
Great. Okay, good. We're back up. Thanks. Perfect. Okay. Great. So again, the overview of I don't know where it cut out. I'll just start. This was a slide. Okay. Complete. Okay, great. So you have to have jurisdiction within one of those resource areas, and then an application of some sort which we'll discuss the different types, is filed with the Conservation Commission. There's generally a public hearing of the Conservation Commission and perhaps also a site visit, if not by the entire commission, hopefully the staff. The public hearing then closes and the commission deliberates and determines whether the proposed work complies with what we call the performance standards, the requirements of the state regulations, as well as the local regulations. I'm oversimplifying that. There's often a lot of back and forth. There's multiple meetings on complex projects and things, but this is the general process. Once the commission reaches its decision, they'll vote and they create and issue an order of conditions or a permit. It's an issue, it's called, the permission form is called an order of conditions under the state act, and a permit under the bylaw. So they will write something up. There's an order of conditions form, and generally they either deny the project, saying it doesn't meet the performance standards and our requirements, or they'll approve the project as proposed, or more often than not, they will issue a permit and order of conditions with many conditions on it. These permits and orders of conditions must be recorded in the registry of deeds before work can begin. So that's a good way to find out if you see some activity going on and you know the property, you can check the registry of deeds, or if not, the Conservation Commission office, to see if a permit has been issued. And they're generally good for 3 years. Once the work is complete or the permit has expired, the applicant, the person who's applied, will apply for what's called a certificate of compliance. They're essentially asking the Conservation Commission, please issue the form that I can record in the registry that says the order of conditions that I've recorded against my property has been completed as we proposed. So in terms of the types of applications, sort of the lowest level, the simplest level is administrative approval. This is for, and I'm not sure if Plymouth actually adheres to this. This is more of a practice. It's not necessarily written, certainly not written in the state act, and many municipalities who have their own bylaws have some provision in their regulations, many don't. But this is for something minor, like removing a tree that's dying and about to fall over. You wouldn't want to necessarily go to the Conservation Commission for that, or adding a step in the floodplain to your porch or something of truly minor nature. It's just the administrative staff deals with it. They often might not even run it by anyone at the Conservation Commission. They might tell the chair about it, but really, really minor things.
Question. You said that's not a provision in 310 CMR. I don't believe that's specified in the Plymouth bylaw.
Okay.
So if it's not specified in either, is it still legal for them to do administrative approvals?
It's one of those things where it's technically, technically it's not legal. They should be bringing that to the commission. But I think it's a practical matter, administrative matter, when you have many battles to fight, many applications at you, I think as a matter of administrative efficiency, it's done pretty routinely around the state, even if it's not truly legal.
Is
So
that
it's
typically
common practice.
delineated in a policy statement?
It's typically, the best practice is to have it in the local regulations. And actually my Conservation Commission is just doing this now. We're trying to decide which of those types of projects are we essentially delegating to the administrator to do. The very, very minor projects. You know, there's a tree about to fall on their house. It's like, do they have to wait the 2 weeks to come to the
Yeah,
Conservation
I
Commission?
understand the scope. I believe that legal counsel's advice on this was that it needs to be specified by the commission that
Yes,
they're granting that approval to the administrator.
yes, I would agree with that for sure.
I have a quick question.
Yep.
So basically, I'm in Conway, Mass. I'm in Western Mass. I'm not in Plymouth, but I wanted to learn about everything I could about wetlands. What are the repercussions if somebody alters a wetland, like breaks a beaver dam? My neighbor did that across the street. Our Conservation Commission has very few people on it. The guy who broke the beaver dam is a pretty threatening person, so they were going to send him a letter. And like nothing's happened. So I just didn't know how Plymouth would deal with such a issue with
that's thanks for joining us. I think that's a question. Why don't we hold that till the end, because I will be going through enforcement later on in the presentation, which might cover some of that. And there's a lot of issues I hear coming up in that question. So if you wouldn't mind reminding us of it when we get to the Q&A, that'd be great.
Okay, thanks.
Thanks. So in terms of the types of applications, again, I wasn't sure if Plymouth had it. It's good to hear where things are at with that. The simplest type of application is called a request for determination of applicability, and you're asked, and this form can be used in multiple ways. You can ask if the Wetlands Protection Act or the bylaw. You can ask if one or the other. And usually people ask if there's a bylaw, they want to know if both apply to just a piece of land. This could be even before any work is contemplated. And anyone can do that. It doesn't have to be the landowner. It can it's just the regulations at DEP say a person. It doesn't have to be the landowner. It doesn't have to be the builder who's planning a project or a prospective purchaser of the property. Any person can do that. You can also ask the commission to determine whether the work that's proposed, so you can actually, in your determination of applicability, say, I'm going to build a single family house. Here's a rough sketch of it, and here's the property. Does the act and the bylaw apply? And if it does, do I need to file a notice of intent, a more complex application, or can I just get by with, or do I not need to? Meg.
You could file it on someone else's land. It doesn't have to be on yours.
Exactly, that's what I meant to say. Yes, so that when I say any person, so you can file it. You don't have to own the land. You can file it. You can file it if you want to know 2 houses down, 2 lots down. You know, is that? I wonder if that's going to have to get Conservation Commission approval. You can file the form with the Conservation Commission to ask that determination. You can also ask a determination of whether what the boundaries are, what the exact boundaries are of wetland resource areas, although that's done less often in this form because of the next application that I'll talk about, which came about maybe more recently, and people use that. That's more detailed. But also for requests for determination of applicability, you can also say confirm an exemption. If you're a farmer, you might just want to have something in writing, a legally operative document that's good for 3 years to confirm that you're exempt from your farming activities are exempt. So people use those forms that way as well. This abbreviated notice of resource area delineation, or ANRAD as we call it. It's a little bit easier to pronounce. And this is the form that's used really just to confirm the wetland boundaries, the boundary of the bordering vegetated wetland, the boundary of the riverfront area. And developers will often do that because before they put the money into doing a subdivision, you know, the engineering, the architecture and all that, or even a homeowner too, they have a lot, you know, where's the best place to put the house? You know, where do I think I can put the lawn and the house and the septic system before I go through all that process, it's nice to be able to confirm that wetland boundary or riverfront area boundary or the floodplain boundary, a number of different areas. And so that's what that form is used for. The notice of intent is the more typical, the traditional, the more detailed application than a request for determination of applicability. And this is for generally you have the proposed work. You don't have, say, construction level documents, but you have very detailed documents about how, especially for stormwater, where would the stormwater basins be? What's the distance and the slopes of the driveway and the roadways and things like that. And that's submitted to the Conservation Commission. And so after the Conservation Commission goes through its process, these are the types of permits or permissions that are given. So for that request for determination of applicability, what's issued are called a determination of applicability. And the lingo is either a negative or a positive. And you might guess a negative, and again, it depends what you're asking. If you're asking, is this piece of land within jurisdiction? A negative is no, it's not within the commission's jurisdiction. But sometimes you can have a negative, which means, well, yes, while there's jurisdiction, the work doesn't rise to the level where you need a notice of intent. So that's a negative, so no. So you sometimes have positive negatives, but and positive or negative positives and things, but generally a negative means a negative is a good thing. Most people think it's a good thing because it's no further involvement with the Conservation Commission. A positive is not such a good thing usually, because it means that yes, you're within the Conservation Commission's jurisdiction, that piece of land is within the Conservation Commission's jurisdiction, or that work you've described and you're asking, does that work require notice of intent? The positive is a yes, the checkbox, so you can't do any work until you file a notice of intent. And then the abbreviated notice of resource area delineation results in an order of resource area delineation. And again, that just affirms the wetland resource area boundaries for a period of 3 years. It can be extended a little bit longer. And this order of resource area delineation is different from the order of conditions. And that's the permit that you get and you record at the Registry of Deeds that is the result of the notice of intent process. And again, as I mentioned before, these two processes under the bylaw and the Wetlands Protection Act are simultaneous. I mean, the hearing notices will say the Conservation Commission is holding a hearing under the Wetlands Protection Act and the Plymouth bylaw, blah, blah, blah. And the timelines are all the same. So although they're two different laws, technically they are handled together. And sometimes it's hard to distinguish which is which in the process because they're so well combined in many instances. I understand that there's a waiver provision in the regulations of your commission, which is one that's similar to others, although the standards are a bit different here. And essentially I've broken it down. And so this waiver provision, and again, this is in the regulations, not in the bylaw. There, of course, is some debate is, can you legally have a waiver provision if it's not allowed, if it's not specifically set forth in the bylaw? We've had this debate in our office. There's this sort of strict line of view that if it's not in the bylaw, then you can't have it in your regulations, right? And then there's another line of thought that says, well, to avoid, say, a regulatory taking of property, you need to have, as a matter of administrative law, which is a whole nother body of law, which is sort of underlying much of the Conservation Commission processes. A waiver provision is something that is allowed. So I don't think the case law is settled on that, but at any rate, in your regulation, in the Plymouth Conservation Commission wetland regulations, there is this provision that says that the commission may at its discretion waive the provisions of its regulations when it decides that the work potentially represents a significant ecological improvement when compared to the existing conditions. So I would think that would be someone restoring a salt marsh or a pond or a wetland area that has been damaged somehow, maybe by a flood or a natural event. Or if they determine that it will not adversely affect any areas. And I think in my mind, that will not adversely affect any areas. That's a provision that rings in my mind of the determination of applicability process, because that's essentially asking a conservation commission through the request for determination of applicability process, will this proposed work not affect any of the resource areas? So I find that from a legal perspective, a little bit confusing and some potential for confusion and overlap. Importantly, a waiver may only be granted in exceptional circumstances and only upon a written request. And furthermore, the person making the request must demonstrate that there are no alternatives and the proposed work will contribute to the interests of the act. I think a significant interest of the wetland bylaw. And related to wetlands permitting, as I touched on before, is stormwater. Stormwater is important because it's, many of these wetland resources, of course, it's hydrological, there's water. And so when you have stormwater, which falls on the ground and runs off across a project site, you can have impact on the resource areas. So the Mass DEP about 20 years ago developed stormwater standards, and there are 10 of these. And they don't apply to single family home developments. They kick in really at only developments of 5 or more lots if it's a subdivision, and also most commercial and government projects as well. So larger projects. And they also don't apply for any emergency repairs that are needed on roads, roadways, or drainage systems. So as part of the notice of intent form, you have a stormwater checklist if the stormwater standards apply to you. And you get this really hefty, usually several hundred page stormwater management report prepared by an engineer, and to help demonstrate that they meet several of the stormwater standards. And again, this is all happening during the usual wetland permit review process. I'm not sure if Plymouth has stormwater standards of its own. I couldn't figure out from the website. Many municipalities, the larger municipalities, are required by EPA to have stormwater standards and meet the municipal stormwater MS4. I'm acronym failure. The MS4 program.
I believe that Plymouth follows the state act here.
Right, yes, and also I should mention that DEP is in the process of developing and will likely expand and slightly tweak these stormwater standards. That they will add an 11th stormwater standard as well. There's also a stormwater handbook which supports these 10 stormwater standards, and that's also a good resource as well. And this is just a list of the stormwater standards. They can be found in the DEP regulations on the DEP website. There are the 10 standards. The ones that often come into play is standard number 2, which says that there cannot be a increase in the peak discharge rate of the stormwater flowing off the property. It's measured usually at the property line. And so it's the rate, it's not the volume. Many municipalities will also add the requirement that there cannot be a change in volume, but the state standard is no change in the peak rate there. So that one often comes into play and is often hotly contested. Also, recharge to groundwater. There's a preference to not throw water off the site and to have it soak down into the ground right there. So there are some low impact design standards that are in the current stormwater standards that apply. And then also the standard number 4 touches on the requirement to remove 80% of total suspended solids. So you hear about storm scepter units and other such devices. They're called BMPs, or best management practices. Those are used to try to meet this standard as well as other standards. Standard number 7 talks about if you're redeveloping a site, the other standards, the first set of standards are really first contemplating developing a site that hasn't been developed. There's no existing things. Standard 7 is for, you start there if you're redeveloping. Let's say there's a shopping mall and it's going to be converted to an assisted living facility. That's the type of thing, a redevelopment project, and that will trigger that standard. And this standard in turn relaxes some of the other standards. So we could have a whole forum on the stormwater standards. Importantly, the last couple of standards do talk about erosion, erosion controls and sedimentation controls during construction, as well as after construction. operation and maintenance, you have these things called BMPs, detention basins, retention ponds, constructed wetlands, things like that. Well, you want them to continue working, and so there's operation and maintenance plans to have that happen. And then the tie into endangered species, someone was asking about that earlier. There's because of the Wetlands Protection Act protects wildlife habitat. It also protects wildlife habitat of endangered species too. And so that overlaps with another state law we have, which is administered by the Natural Heritage and Endangered Species Program called the Massachusetts Endangered Species Act. Many have heard of the Federal Endangered Species Act that's been around, I think, a little bit longer than the Massachusetts one. But the Massachusetts Endangered Species Act has its own list of endangered, threatened, or species of concern. Many of them are also on the federal list, but I think there are more. I believe there are more on the state list as well. Natural Heritage, of course, has its own regulations about how the Endangered Species Act is going to be administered. And they essentially administer this by reviewing projects in certain areas. We'll talk about that in a minute, and try to determine will there be a sort of really a destruction of the species or its habitat. So it protects the species itself as well as the habitat. Unlike the Wetlands Protection Act is just focused on the habitat of the wildlife. So DEP has mapped the areas where they think any of these rare species have appeared. People report sightings. Qualified biologists report sightings. The staff goes out if they're on a project site. They'll look at things and see if they see like a salamander or a type of turtle and things like that. So Natural Heritage has a huge database, and from that database, they've mapped the entire state called priority habitats. And then there's a subset of the priority habitat, which is called estimated habitat. And that's just for wetland dependent species. And that's where we've got the intersection with the Wetlands Protection Act. So just as an example, so here's an excerpt of Plymouth, and can you folks read that those two ponds? I think it's South Pond, is it Big? And Miles Standish over there, so a portion of Plymouth. So this is the priority habitat. Now you can find this on the Mass Natural Heritage website. There's a whole mapping program, Mass Mapper here. So this shows the priority habitat. So anyone doing work within this area would have to apply under the Endangered Species Act to Natural Heritage to see if they get approval, or they need a take permit if there is going to be a take for any work there. So this screen here shows the estimated habitat and the priority habitat. The priority habitat is in yellow, the estimated is in green, and I'll show that here, right? So here we have just the estimated habitat. So if you are applying to the Conservation Commission, you're within any of those wetland resource areas we discussed, and you're within this, estimated habitat, then you do need to send a copy of your application to DEP, and you file that with the Conservation Commission, and you send a copy of that to Natural Heritage, because again, there's overlap in terms of the wildlife habitat viewed from the Wetlands Protection Act point of view, as well as the Endangered Species Act point of view. So under the DEP's regulations, Natural Heritage has 30 days to provide a comment to review it. They will write a letter to the Conservation Commission to say whether there's actual habitat. So again, they go back and they look in their database and they say, well, we've mapped it, but let's look at this parcel in particular. Is the species for what that area is mapped? Is it actually near that parcel or not? So they will say whether there's actual habitat, and then they actually provide a recommendation under the Wetlands Protection Act as to whether there's an adverse effect, because that's the standard under the Wetlands Protection Act, is you cannot do work if you have an adverse effect on rare wildlife habitat. And they will also say in their letter that whether or not they consider under the Endangered Species Act whether there will be a take of that species. Related to wildlife habitat is a project that was done in 2010 by, again, the Natural Heritage and Endangered Species Program, as well as the organization called the Nature Conservancy, hopefully many of you are familiar with. And this was a project that they came up where they mapped the entire state into different habitats, essentially. And they have the core this is divided roughly into the core habitat, which these are the areas, and I'm going to read from the definition. It's a little complex here, but it identifies key areas to ensure the long-term persistence of species of conservation concern, exemplary communities, and intact ecosystems. So essentially the prime areas that should be not touched because these are great habitat for endangered species and will provide biodiversity throughout the Commonwealth. And there are subcomponents. They've defined subcategories of this core habitat. The ones that are most relevant to wetlands protection is the wetland core and the vernal pool core. So there are different characteristics there. And a lesser landscape, but as important in many ways, is the critical natural landscape. And this is a larger landscape, the areas that are better able to support ecological processes and things, but they're not quite as critical as the core. And Meg may have more to add to that because she's, I think, has more knowledge of the biomaps than I do. But the important point here is that while these biomaps and the core habitat and the critical natural landscape don't have any regulatory weight like those estimated habitats we just discussed with the natural heritage, this is still a really good resource to, if you're looking at a piece of land, going to this resource and saying, oh, okay, it's within the core habitat or it's within a wetland core. It's really good evidence to present, say, to the Conservation Commission or the developer to say, hey, look, this is core habitat. This is really, if you alter this property or not careful how you do your work, you're really going to affect the biodiversity and wildlife of the Commonwealth. And for just example, here again on Mass Mapper, the core habitat is the area in green. This is, I think you can see the entire boundary of Plymouth there. So that's the core habitat. And then we have the critical natural landscape in the light green. So you see that there's definitely overlap. I think the critical natural habitat should be bigger than the dark green that we just had before. So moving on to enforcement, which is something that many members of conservation commissions, it's their least fun aspect of their job. Ditto with administrators as well. But an important thing to implement the laws is not just permitting, but also making sure that people follow the process and obey the law. So enforcement is important, an important part of a conservation commission's responsibility, even if it's not the most pleasant at times. So I'll just give an overview of enforcement quickly. So really, what constitutes a violation? And this varies between the Wetlands Protection Act and the bylaw a little bit. There's general overlap, but DEP has also defined some things through their regulations as to what constitutes a violation. So the main thing is if you remove, fill, dredge, or alter, i.e. do any activity without a permit, that's obviously a violation. Also under the state law, if you cause, suffer, or allow such activity, so if you're somehow responsible, so let's say you've hired the contractor, you can't just blame it on the contractor, you can be held liable as well. If you leave in place unauthorized fill, you filled a wetland, if you leave it in place. If you fail to restore illegally altered land, if you fail to comply with an enforcement order issued by a conservation commission, or you have a permit and you fail to comply with the order of conditions itself, that's a violation. And if you also fail to comply with some other provisions of DEP's regulations. Under your bylaw, very similar, the core concept is the same. If you do work without a permit, remove, fill, dredge, and alter a wetland, you are liable for enforcement. If you have a permit and fail to comply with it, interesting, unique provision I saw here is that if you fail to complete the work that's allowed in the permit and the failure to complete that work causes damage to the wetland resource areas, you can be liable as well. If you fail to record a permit or an extension of a permit, that also is a violation under the act as well. And similarly, if you fail to comply with other provisions of the rules and regulations of the Conservation Commission, that's enforcement. Often a commission is faced with the difficult task of, okay, we see the violation, we see picture like this, you see dumping on some land. So, okay, who do you enforce against? Typically, it's the landowner because they generally have the activities happening on their land. They're the landowner, they have that responsibility. Sometimes it's the tenant or the lessee who's done the work. The landowner has leased the property to a commercial tenant, and they've thrown drums out the back door and it's rolled down and fallen into a wetland area. Or a contractor, again, they've hired a contractor. The most difficult thing is a third party, which is sort of dumping, someone driving by the highway and just dumping trash out into wetland, as this picture illustrates. There's also, for wetlands enforcement, it's difficult, access to property. And this is also, if you see a violation and passing by and you want to find out more, this is something as a member of the public should be aware of, not just conservation commissions, but getting access to the property is key. You need to obtain the consent of the property owner under constitutional law and property rights. People have the right to exclude people and not grant that. The best thing is to get that consent, obtain that consent in writing. And sometimes commissions will have a provision, if someone's applied for a permit, you give the permission in that context as well. If you can't get permission, it's fine to take a view from, say, a public way, or adjacent parkland, or maybe it's a piece of private property where you can get the property owners. The next door neighbor who's complaining about it might say, yeah, sure, come on my site, come on my property, and we can walk to my backyard and we can see what's happening in their backyard. Short of all that, conservation commissions do have the authority to obtain an administrative warrant. They go to district court for this. This is different from a search warrant that we're all familiar with from movies and TVs as a criminal activity. But an administrative warrant is issued when there's a probable cause standard, when someone says that they have probable cause that there's a violation going on the property, and the district court magistrate will issue a warrant to allow them to go onto the property for specific activities. Yeah, sure.
On the obtained consent, I understand or agree with the statement that it's a constitutional issue, at least with respect to Conservation Commission. But I don't think that applies to an individual.
Well,
For example, search and seizure before.
right, yes, I'm sorry, right. So it's well, that's what I say, or property right. I mean, people have, but it's a property rights issue. You would be trespassing if you don't have permission. You would be trespassing on that person's property. Yes, thanks. Yeah, sorry, I meant to cover both for that reason. And then, so the enforcement options or tools really that a conservation commission has at its disposal vary a bit under the Wetlands Protection Act and the bylaw. Both allow for notices of violation, and these essentially are letters that are written to the property owner, the person they think has done the violation, and asking them to stop the activity. They might also ask them to do something like stabilize the site, put up hay bales, put a cover over that pile that you have, or close the dumpster because stuff's blowing into the wetlands. They can also issue an enforcement order. DEP has a form for this. Notices of violation, if you don't obey that, there's no legal consequences. But as I mentioned before, enforcement orders, if you disobey an enforcement order, that in and of itself is a violation. So you have the underlying substantive violation, and then you could also have you could be liable for ignoring the enforcement order as well. So things can add up. Fines are not under the Wetlands Protection Act through what's called a ticketing authority. Your town conservation commission does have this. It's the section of the statute is 21D. So everyone calls it, many practitioners call it 21D ticketing. That essentially looks like a parking ticket and is written and handed out to the violator. It's appealable to district court, and you can issue a ticket for each day that a violation is occurring. So some aggressive commissions will go each day. If they see the violation ongoing, they'll go each day and issue a ticket to the person and deliver it.
And each violation. as well.
Yes, right, exactly. Thanks. Yep, for each particular violation. Yes, for sure. And
And
then,
that is capped at $50 per violation per day.
yes, thank you. Yep, you guys have defined that, or Plymouth has defined that in your regulations. So ratcheting up the complexity and the severity of the tools that are available, then there's also going to court, a civil action. You can seek an injunction. And I think most of you know what an injunction is. It's usually in terms of prohibiting something from happening, but it also can require someone to do something. And injunctions, there's generally a permanent injunction is issued after the judge has a trial, decides on the merits, and issues their decision. It's a permanent injunction. As you might know, you might be able to go to court and apply for a preliminary injunction, which is essentially you need to convince the court that things need to be done before the judge actually decides. And there's a balancing test that the judge does to determine whether preliminary injunction can be issued. The Wetlands Protection Act provides for penalties. Again, in a civil action, the commission itself, and this is a surprise to many commissions, they don't say, here, pay us $25,000 a day. You actually have to seek that. You have to have it. You seek in your complaint to court. You ask the judge to order the person to pay penalties. The bylaw does not have that provision for a civil action. Things are more serious for really egregious violations. Criminal prosecution comes into play. So this is under the Wetlands Protection Act, fines can be imposed and even imprisonment. And I think, I don't know, I'll see if Meg knows of anyone. I think I've only heard of one person in 35 years being imprisoned for a very short time or being threatened to be imprisoned. I don't know if Meg knows of anyone else. So that's rarely done, as I mean, many conservation commissions feel that the person should be imprisoned right away, but no, that is a very harsh remedy. The bylaw does not allow that. DEP can help. The Mass DEP can help with enforcement under the Wetlands Protection Act, but they cannot do anything, cannot help out a conservation commission enforce their bylaw. That's just, yep.
A cease and desist. They can issue a cease
Sorry.
and desist under a enforcement order, essentially.
Yes, yep. So yes, with an enforcement order, they can say cease and desist. Even in the court complaint, that can be one of the relief, the things they ask the judge to say is order the person to cease and desist this activity, which is causing harm to wetlands. And DEP does have a set of tools itself that it can use under the Wetlands Protection Act. They can actually issue penalties directly to which the Conservation Commission can't, and they have other tools and procedures as well. And just enforcement orders here, just a little bit of detail. This is probably too much into the weeds for folks, but under the Wetlands Protection Act, the commission or members or an agent can issue an enforcement order as long as it's ratified at a later meeting. My reading of the Plymouth bylaw, by contrast, is that the commission itself, I believe, so they would need to vote at a meeting to issue an enforcement order. And the important thing, I'll just go towards the end. These enforcement orders are not appealed to DEP. They are appealed to Superior Court, and they have to be appealed within 60 days. So fines and penalties. Again, this is something that many commissioners get confused about. They think that they have the authority, an enforcement order to say, do this, this, and this, and then pay us also $5,000. But no, they can't do that. Under the bylaw, you have the $50 a day ticketing authority to district court. So the Wetlands Protection Act allows for, under civil actions, a penalty of up to $25,000 a day, and under criminal actions, up to $25,000 a day as well. Again, the DEP weighs, they have a formula for the severity of the violation. I think it even comes down to, how many square feet of a wetland resource area has been damaged and things to calculate that penalty, because it's rarely the maximum. So question.
That's $50 per violation.
Yes. Yes, per day. Yes, thanks on that. And then it's a couple of things to remember in terms of the bylaw penalties, the tickets. Some commissions think that they can be added to the tax bill. They cannot, or collected by a lien. No enforcement documents should ever be recorded at the Registry of Deeds. because that creates other issues as well. So in terms of,
Can you go back?
sure,
Enforcement order cannot include the fine.
that's right. Yeah. So the enforcement document itself, you cannot, in the document, you can't say pay up X amount of dollars. That's really just to say, do this or that.
And so that
file
it's
thing.
not done that to do the ticketing. Is that correct?
Right. Well, you can do that actually under the bylaw. You could do both. You could issue an enforcement order and issue a ticket because they're separate. They're two different tools, so you could use them simultaneously. One does not have to be after the other. And in terms of if your Conservation Commission is not doing, you feel like it's not doing its job, maybe you disagree with the permit it's issued, you think it's not sort of enforcing and administering the Wetlands Protection Act. Certain people can appeal orders of conditions. Again, that's the permit under the Wetlands Protection Act, as well as determinations of applicability. I didn't list that there, to DEP for their review. They'll issue a superseding order of conditions or superseding determination of applicability, or even superseding order of resource area delineation. Generally, it's the landowner, the applicant can appeal if they're not happy, say they got a denial or something, they can appeal. An abutter can appeal that first stage. So if you own the abutting property, you can appeal. And then also 10 residents of a community of Plymouth could appeal to DEP. The permits and the determinations that are issued under the bylaw, those are appealed to Superior Court only, not to DEP. Members of the public can also report potential violations, call the conservation administrator, send pictures, provide information, or report it at a Conservation Commission meeting and ask for enforcement. You can also ask DEP if you feel that your Conservation Commission isn't doing something and there's something really egregious. I mean, DEP has a lot on its plate and it's very busy, but they are interested in the most notorious and egregious violations. And it's always a good idea to contact them as well. Yes.
One that we would contact would be the one in Lakeville. Is that our?
The Lakeville, yes, that's your regional office. Yep. So you call the wetlands program there, the wetlands chief, and report something there. This is, yes, these are, well, the first part about the appeals, the first bullet is the reporting, there's the reporting the potential violations. The next bullet points are not, because those are just making a request. So if you're appealing a permit or determination through the wetlands process, you can, but if you see a violation that isn't covered by a permit, because often a member of the public might see a violation, might see an activity that they think is a violation. They call the Conservation Commission office and the Commission office said, yes, we just permitted that project. But usually permitted, if work has been permitted, there should be a DEP file number posted. So that way you'd be calling the office and say, hi, I'd like to look at the file for that DEP file number just to understand what the work is, because I have a suspicion. You might then say, I have a suspicion that it's not being done in conformance with the permit or something like that.
So maybe you're going to spend more time on enforcement. You may have sensed a number of people in this room are very keen on.
Sure, yeah, and we can actually. This is the last slide on enforcement, and we can. We're almost at the end, so we can totally discuss. Yeah.
Damage to property. I'm not in a butter.
Yeah.
Do I have any legal rights other than getting 10 persons together and initiate a lawsuit?
Well, 10 people, right? And so, right, I was gonna say, so the second to last bullet here is you can go to Superior Court, 10 people. That's not going to DEP. That's just saying there's a violation. There's 214(7)A, 10 persons. They don't even have to be all residents of Plymouth, for instance, can file a lawsuit in Superior Court alleging a violation of the Wetlands Protection Act or the bylaw, and proceed that way. And things. And then the last bullet point is if you are, let's say, the adjacent property owner to where there's a violation that's occurred. This is more of private property law. So let's say someone's building a house on their property and you have a nice pond in your backyard with a little wetland on it, and their construction goes awry and it fills the wetland. Not only is that a violation of the Wetlands Protection Act, but you could sue for damage to your pond, your wetlands, your personal property. So that's what we call sort of a private property action and things. It's not under the wetlands laws, but it's the same. The goals are the same as to have a nice pond, have functioning wetlands on there. And we're at, okay, yeah, we're towards the end, just some other local boards that have that have laws and do things, have regulations that might affect Plymouth's water bodies, wetlands, and other resource areas. The Board of Health, I believe all of Plymouth has septic.
No,
Yeah.
very little.
Oh, very low, okay, very low septic, okay, great. Septic systems, everyone has a Title V, yep. Not everyone, okay, not everyone. Okay, so there's some town sewer, and then most everyone else is on septic.
Correct.
Oh, okay, good, all right. So, what the Board of Health does has an effect on what the regulations under the Title V, the state septic law regulations say, and there might be more stringent standards, hopefully in Plymouth, that would help protect these resources. Site assignments for, say, God forbid, a landfill or something like that, the Board of Health does site assignments for that. The planning board has subdivision control regulations, which again, a lot of that is focused on drainage, which affects wetlands and waterways, and then special permits for different uses. The planning board has the ability to provide conditions that actually might help or might harm wetland and water resources. Then about your zoning board of appeals, variances that could vary the provisions of certain zoning provisions, which have a focus towards trying to maintain the beauty or the natural environment or the floodplain or something in Plymouth. So variances may affect that. Again, special permits, I'm guessing that the zoning board also issues special permits in certain situations. And then comprehensive permits, 40B permits for those affordable housing projects. Those also can have effect on wetlands. We're often seeing that many 40B projects like to try to get exemptions and waivers of their local wetlands bylaws to, for instance, to fill more of the floodplain, to fill more wetland and things like that. And then your building commissioner administers the zoning bylaw as well, and also the building code that comes into play now because there's provisions, especially along the coast, to have the first floor elevation at a certain height above the base flood elevation, and that increases when you're in the velocity zone, and that's in response to federal standards, and that those building code provisions are there to maintain the community's eligibility for the FEMA flood insurance. So there's financial incentives there too. There's also a provision under the Zoning Act for citizens to file a zoning complaint. So it's not a wetlands complaint, but a zoning complaint there. And for more information, the Massachusetts Association of Conservation Commissions is a terrific resource. They have a website, and hopefully I believe the Plymouth Conservation Commission is a member. You don't have to be on a conservation commission to join. They have a great annual environmental conference, the first March of each year, and they have a fall conference coming up. The fall conference this year is going to be about focusing on using your wetlands regulations to help build your community's resilience to the effects of climate change. And so it's a very modest membership fee. I would say my experience is about half the people who attend these conferences and are members are not on conservation commissions. They're just citizens who care about conservation. It's not just for conservation commissioners. And their quarterly newsletter, the Conservation Quarterly, is also another wealth of information with articles in it, some by yours truly and many others, and just great resources. Developments of DEP is a great way to keep informed. They also publish online the environmental handbook for conservation commissions. Again, it explains in a little more detail many of the laws and concepts I went through, and much more. I mean, this has just been a scratch of the surface of what that treatise covers, and that's only a $15 per year subscription, I think, on top of your MACC membership, and I think that's one of the best bargains around. Mass DEP, of course, their wetlands division, they have many good resources. And then in terms of the endangered species items and then Endangered Species Act, that's natural heritage as well. And then, of course, I would be remiss to not to mention my law firm's website, which there are attorney blogs, which covers some of the cases and some of the principles and developments that have happened. So feel free to visit that often on that. So now with the Q&A, thanks very much. I hope people found it informative and not overly confusing. I threw a lot at you. So. Thanks. So can someone monitor questions on the Zoom? Okay, yeah, I think it's a good idea. Yeah, sorry.
Nathaniel, just as a reminder, if you're taking questions from the room, you need to repeat them because we can't.
Sure. Yes, sorry. So Meg was just saying that she has put on the website. I guess, are you putting it in the chat or? She put in the chat. She's just saying that she's added the PowerPoint slides to the website as well as some other resources.
And I have also added the link if you want to be on the Save the Pine Barrens mailing list or be a member.
Okay, great. Thanks. Good. Okay, yes, and there's a sign sheet. Sure. Yeah, we'll take some questions. I'll take one or two from the room, and then if folks, I guess, raise your hand on the Zoom. I can see the Zoom, so I can try to multitask, and Meg will help me on this. So that'd be great. Whoops. Oh, turn the volume up on.
So we can hear people.
Oh, sure. Yes, you're asking questions. Yes. Okay. Yeah, we'll repeat the question as well.
Okay, that's
It's Max. Okay, great. Okay, I'll turn to the audience here in the room in Plymouth. Yes, sir.
We have a watershed association situation where we get continuing number of missing clear cutters on our pond. This after 2 years in a row, not this year, fortunately, of cyanobacteria and increased runoff. And we've gone from maybe 2 offenders to about 8 or 9. We've had the conservation commissioner come out with the armed gun of the town, whether he's seen it, he has basically refused to take any action. The court's going to throw everything out that he does. We've taken his boss out. I've showed him personally his sites. I'm wondering what recourse we have to, what would be your course of action to force the Conservation Commission to do what they're doing?
Sure. So just repeating, I'll summarize the question for the folks on Zoom who probably didn't hear it. The gentleman was noting that around his pond, there's been increasing cutting of trees and vegetation, and on steep slopes that was maybe 1 or 2 people in the past, and now it's many more people. They've brought the conservation administrator out. They brought, I think, members of the commission out or other town officials, and had no response. So what do they do? What would be a course of action? Again, the options are try to get DEP involved. Again, contact DEP. That's probably the least costly option. Another approach might be you could file, if DEP does not take action, you can force the issue by filing a request for determination of applicability. With the Conservation Commission, you would expect that perhaps you can predict what the Conservation Commission will probably say and determine and say that no, there's no violation, essentially, no permit is required, and then you could appeal that to DEP, and that would get that in front of DEP's face in another way. The more extreme is get 9 other persons in the Commonwealth and file a suit in Superior Court arguing a violation of the Wetlands Protection Act and the bylaw and things. So the defendants in that would be the property owners, not the town.
You can't get the commission as a party.
They don't have to, I mean, sometimes they do, and DEP, sometimes they would join. You don't sue them. You sue the violators under that provision, not the people who are supposed to be enforcing it. There's some notice provisions and things like that, and again, more complex, more costly. Ideally you need experts, ideally you need an attorney and things like that. So, and a lengthy process.
I ask one more.
Sure, just as sure.
Quick one is, what if somebody buys property which violations occur? Are they liable? People who have bought the property?
The question is, what if someone buys a piece of property which is an existing violation? What are they liable? And yes, in fact, they are. And actually, in the last year, the Supreme Judicial Court clarified, interestingly enough, but just the way the statute has been written, answered the question that many practitioners had for a while, because the Wetlands Protection Act says generally there's a 2-year statute of limitations, but for people who acquire property, there's essentially a 3-year statute of limitations. So folks thought, well, is it 2 or 3 years? And is it, the 2 years plus the additional year? Let's say the person purchases the property, but the court said in a case in Norton where the violation occurred in the 70s, I think, or 1980s, and the commission tried back then to get the person to cure it. They didn't, to respond. And then it went on and the property was sold 2 or 3 more times, or 2 more times. And then the commission, it must be now, it took 10 years to get through the courts. 10 years ago, so we're talking about 2010, essentially issued another enforcement order because the person just purchased the property. And the property owner said, you've got to be kidding. No way. It's it's 2 years. It's 2 years, or maybe it's an additional year. But the Supreme Judicial Court, the highest court of the state, said, no, the way it's written, essentially the commission gets the bite at the apple each time the property is transferred. So they got another. If they've missed it, if they missed it before and the property changes hands, voila, you get to try again. So I would expect the legislature might cure that. So sure. You're welcome. Thanks. Sure. Meg. Yep.
To add one more thing.
Yep.
In terms of another enforcement option, under the bylaw, you can go strictly under the bylaw instead of going to DEP. You can request enforcement under the bylaw to say, tell this person to stop doing this and also to fix this or replant trees. And then if the Conservation Commission denies your request for enforcement, then you can go to Superior Court, which is what we've done in Carver with a really egregious situation there. Right? I have that right?
Yes.
So that's 2 words.
Why don't I take, let me go to someone online. Oh, if you have a related question to that? Sure. Okay. Sorry, folks on Zoom. We have a related question, so we'll go to that.
Microphone over there.
Yeah, if you can.
Yeah.
My question is whether or not cyanobacteria is increasing, around, and who is responsible for looking at ways to mitigate that in all the ponds in the area?
Good question. Yeah, I was going to say the Board of Health. I think it's the Board of Health if it's a public health issue, right? Because there's sometimes dire effects of that. More from the ecological point of view, I mean, ideally, yeah, that's a difficult question. It's because no one's really, I mean, there's not a, it's hard to say, I've got to choose my words carefully. There's not a single person who's responsible for that, perhaps. I mean, it's a result of cumulative practices in the watershed, throughout the watershed, that's causing the cyanobacteria to be there. A conservation commission might take the lead in trying to get a solution to change practices, or educate people. Or in my town, there's a Spy Pond committee. The committee, they will do flyers and things like that and urge people to change their landscaping practices to reduce the amount of phosphorus and things that get in there, which is one of the, I think, things that help cause cyanobacteria to bloom. So a difficult question, no easy answer. I don't know if Meg, you have any thoughts on that one, but good question. Yeah, it's a difficult issue. So. And then we'll go to What happened on, okay, the Zoom, we've got a Zoom, we have a,
He's right outside.
yeah. Yeah, we have, okay, sure, Devlin, Selman, I guess, unmute yourself if you can. Yep.
Hi. So yeah, I've again, I'm from Conway, Mass,
Oh, okay, yep.
and we have we've had a lot of disasters happen around our property regarding wetlands and destruction of them. I'll try to be really quick just to give a summary of what you're looking at. And I have a few questions. So just my first thing is Nexamp is a industrial solar company, and they clear cut 30 acres of forest behind our house near the highest peak in Conway in 2020, 2021. They cleared the trees and they put in all of the panels on a pretty steep slope. When we went to the Conservation Commission meetings in my town before they did this, they wanted to clear cut up to 10 feet away from the wetlands. And our chair said, you know, can we keep it at the 100-foot buffer? And Michael Scott, the guy that was one of their contractor people, said, you know, we can take you to court because it's not in your bylaw to have the 100-foot buffer zone. But so my first question is the 100-foot buffer zone in the State Wetland Protection Act? Or is that like, does our town have to have that language in our bylaws to uphold it?
The language, yes, the buffer zone concept is in the state act. Again, they review work in the buffer zone under the state law as will it affect the adjacent resource area.
Okay.
A municipality, does your town have a bylaw? No,
Oh,
wetlands bylaw?
we've altered our bylaws. It went from a 2-page bylaw guidelines to over 10 pages because of all of the disasters that have happened.
Okay.
With them kind of taking advantage of our town and our small community. Me and my family's property and our neighbors just went through a lot, and we're still going through a lot. The site has actually been shut down since January. They haven't been producing any electricity because they were pumping out dirty electricity into our homes. That's a whole nother story.
Sure.
But basically there's been tons of erosion going into the surrounding wetlands all around it. There's an isolated wetland in the middle of the array, so that thing is going to fry because it gets so hot up there. And maybe I'll have to like reach out to you like privately to talk about.
Sure. I was gonna say, it sounds very detailed.
The one thing that I was really wanting to talk to you about is across the street. After all this happened in May, our neighbor destroyed the wetland across the street by breaking the beaver dam. So I notified our Conservation Commission. The person who did it is a very intimidating person, has a lot of guns, not to get political, but very Republican, like I can do what I want, it's my land. And so he's very threatening, and our Conservation Commission head is pretty afraid of the person.
Well, I think in this instance is one where perhaps trying to get DEP involved because they're not involved in the local politics would be my suggestion, bring it to their attention.
Okay, because I did document an American Bittern. I documented an American Bittern and sent the recordings to the Natural Heritage, and they got it documented. So I did just reach out to them as well.
Okay, but I would suggest DEP would probably be a good bet.
Okay, all right, thank you.
Sure, yeah, I'd be happy to talk further, offline about your other situation, more detailed.
Okay, thank you.
Thanks. Okay, going back. Let's see, someone in the room, yes. Let's get, sorry, can we get let's get the microphone to you so I don't have to summarize and.
You're talking about land, whether it's above water or below, but what about what's on the water? Semi-permanent items like buoys and docks and things like that that are stationary on the water. Who has control of that? Who has responsibility?
Well, twofold. Those need to be permitted under the Wetlands Protection Act because they're on a water body. I mean, if they're on the ocean, they're over land under the ocean. And DEP's regulations are very concerned about, let's say, eelgrass. Will it Is it in the eelgrass area? Is it in a shellfish area? There's land under shellfish. So
So
you need to. No, it's the Conservation Commission. So you get it's still conservation. It's both. Yeah, it's both. I mean, it's primarily you apply first under the state law, which is ultimately DEP's responsibility. That application first goes to the Conservation Commission. There's another side of DEP called the Waterways Division, and that's for a license that is giving you permission to occupy that portion of essentially use that portion of the ocean because, or the water body, because that's owned by the Commonwealth. And so they're essentially giving you a license for a fee to occupy that. So there's both wetlands permitting as well as Chapter 91 permitting in that case. Sure.
Bottom line, I mean, a resource area, a resource, tell me if I'm right. A resource area is also open water, right? I mean, it's
Well, the land, yes, the land under the water,
Right,
essentially.
okay.
Yeah. No, I'm sorry. Yeah, the act defines it under the water. I think your bylaw does talk about the water, the water itself. You know, it's talked about streams and where is it? It was streams and water, estuaries, salt ponds, and its buffer zone. And then the inland had another one. Yeah, creeks and streams. On that, okay. Anyone have their hand raised online? Raise your hand if you have a question, otherwise we'll ask anyone in the room. Yes.
So
Microphone. Come on over.
You mentioned in the notice of intent process that that's a detailed document that says what they're going to do. And I've noticed recently on a lot of the proposals in our local conservation committee, I'm on the planning board, so I'm used to seeing detailed documents, and the ones I'm seeing are pretty rude and crude, and the board doesn't seem to know what's shown on them. So I'm thinking that that doesn't qualify as the proper document for a notice of intent. They shouldn't proceed with that. What's the level of detail and who determines that?
Good question. Many commissions actually have very detailed standards for what those plans should look like in their local bylaw and their local regulations. DEP also has in the notice of intent form, I think the details, use a scale. The scale should be not, and I just get this, not more than or not less than 1 to 40 inches and things. But I would think on the planning board, you're seeing certainly more detailed plans than a conservation commission sees, but it's really up to the commission to say, is there sufficient information for me to determine what the effect will be on the resource areas? But there's not.
So yeah, we often see blueprint size things, at least we can access those.
Right, online.
I'm
Yeah.
seeing these things that look like they're 8.5 by 11 sheets, where you can barely determine what you're looking at.
Oh, I see. Right. No, there should.
Is there a basic, level of detail, or so you can really see what you're looking at?
Again, there should be, and again, I think the DEP instructions provide the baseline. DEP instructions provide that. Some conservation commissions have very extreme, they look like subdivision control regulations in terms of, for this type of project, you need A through ZZZ, in terms of scale, size, even what color you mark your resource areas. I mean, it varies community by community, but certainly a commission has the power to deny a permit for lack of information. So if a plan is not detailed enough information, they could say, look, I can't even see the resource areas. You're not showing where you just have a blob where the house is going to be, where's the driveway, where's the septic system? If that information is not provided, even fundamental things of, how far is it from the resource area? What's the slope? Things like that. What are the soils? Then a commission has the power to deny that. Sure. Any other? Yes, sorry again. Yep, sorry, can we get you on the microphone?
Do citizens have the right to recall members of a conservation commission?
That depends on your town charter and your bylaws, really. Again, that's a function under the State Conservation Commission Act. I'm not aware of such authority. It's the the people who appoint them can dismiss them for cause, I think, but I don't think there's any petition for review. Meg has a further comment.
Yes, we've been looking into this in another town, and the Wetlands Protection Act statute says something to the effect of the selectmen or whoever appointed the Conservation Commission members can issue like an order to show cause, and then they have to have a hearing, and the person has to come in and explain why they should be able to remain on the commission. So that is something you could do, write a letter to the select board. And then there's also under the charter and the bylaw, probably different provisions.
As an addition to that, no, there's a conflict of interest clause. Is there any way to demand what the background is of each of the commission members? So you can find out whether there's any financial interest in the decisions that they make. Can you require them to have that?
I'm sorry, are you?
Can you require that?
Can you require-
A Concom member, give you a background, their CV, for example, to find out whether or not they have a financial interest in the decisions they're making, since there is a conflict.
Right, so yes, there's a state ethics law, conflict of interest law, and the question is really, can you ask, I guess, go to a conservation commission meeting or otherwise ask someone to say, do you have, give me your resume or give me evidence that you don't have a conflict of interest. And I think that unfortunately, there is not that provision. One has to, you could make a complaint to the ethics commission if you have reason to believe and ask them to investigate it. But it's not the statute, the way the statute is set up is you don't enforce against, you don't have, citizens are not in charge of enforcing it against others. It's really a law where people are supposed to understand the ethics law. They're serving on its boards. We have to do training once every 2 years, at least. When you become a commission member or renew, you get a copy of the ethics law. You hope that people understand that. There may be disclosures that have been filed because there are some instances where there might be a technical conflict of interest or an appearance of a conflict of interest, but you can either file a disclosure with your appointing authority, so it's the selectmen in Plymouth, they would have it, or you can also get their permission too. You would ask the board, you explain to the board what the situation is and say, despite this conflict, I still feel I can make an impartial decision on that. And those forms should be available. They might be redacted in some way, but those types of things should be available. But otherwise it's sleuthing around and trying to collect the information that you have and packaging it up and going to the ethics commission, reporting a violation, essentially.
I can just tell a little story about that. Where we've been working in Carver, a member of the Conservation Commission, Alan Germain, also is hauling sand for the company that is, that we're pursuing for some really serious violations, massive amounts of sand drifting off into a great pond. And all the truck logs for the trucking company showed that he was hauling sand, and he also was making decisions on the commission, signing the order of conditions. We went to the ethics commission, presented them with all of the information, and he was basically told that he had to do some education. So he's still on the commission. We have a DEP site visit coming up next week. I've asked that he not attend that because he does have a conflict, and he, is overly persuasive, let's say. So it's always a challenge, but you should definitely pursue it and try it and let people know that you're watching and checking. That's my view.
It's nice to know that there are people like yourself.
Well, we really need it, and I think that's the best thing that we can do is to
Demand transparency and accountability. Say we're here to defend these resources. These laws were put in place by our state, by our town meeting, and we're going to ask that you explain to us and not treat us like second-class citizens for simply showing up at a meeting and asking a question. So Bill here from Carver can tell us all about it. Oh, right, so we call him the chaperone for the sand and gravel company. He goes around to the planning board, ZBA, earth removal committee. Anyway. Any other questions?
Any other questions from folks on the Zoom or in the room?
We have a map of the 100-year floodplain.
Yes, that's available on the website. We do have a question online, but yes, if you look, where is it? If you type FEMA, I think Firmet, FIRMETTE, I think, and maybe someone online can get the link. That will take you to the floodplains, and you can. What's nice is you can create a map of the property you're most interested in. You know, let's say you want to find out, is this property and how much of this property is in the floodplain, coastal or otherwise. You can actually go and put in the address, and it'll give you a little firm map of the area.
You have something similar for wetlands as well?
Not almost. There's the Mass Mapper program, which is a state mapping program. They have some wetlands delineations, but they're not verified on the ground. But it's a general idea. And I don't know, does Plymouth have a GIS? Does anyone know? I didn't even check. Okay, yeah, heads are shaking. So Plymouth will probably have more specific information and a wetlands layer for there. And we have one question online. Janet, please unmute yourself and ask your question.
Yes, hi. I'm on my phone, so I don't really know how to use what I'm doing here. But I consulted a lot with Meg while I was going through a wetlands issue in my town, and ended up being helped a lot by Meg, thank goodness, but also Mass DEP, and I'm in Western Mass. And I just want to encourage people to feel empowered to deal with these issues. I did do my own delineation. I couldn't find anyone to do it for me, and Mass DEP helped me with it. I found somebody that works as a commissioner or what a staff somewhere. Anyway, long and short is that if I hadn't had that kind of help, I wouldn't have been able to do it. But like, it was horrible what was going on in my property. So I just want to encourage people to not think that you must have a lawyer or that you must have a wetland specialist that would cost thousands of dollars to go out and do a delineation for you. And that's so much of what I'm hoping for, is that people feel like they can, fend for themselves and help, enforce these things in their town.
Great, thank you. That's very encouraging. Thanks. Other questions online? Anyone else online or here?
I do have one more thing. So you have a chance on Tuesday night, tomorrow night at 7:40. There's a public hearing of the Conservation Commission in Plymouth, and I worked with a wetlands expert. It's a project where we filed a third-party request for determination of applicability on a 200-acre piece of property owned by AD Makepeace, and a very globally significant, one of those priority habitats that you saw. So we got a wetlands expert. We filed a very detailed request. We identified all of the work that they have described in a notice, a request for determination of applicability that they filed in 2012, which we think should not have been a negative. It should have been a positive, because their own engineering documents show that they are going to do work in a wetland with pump stations and whatnot. So we'll be asking the Conservation Commission to issue a positive determination of applicability, and also to enforce the bylaw. We brought this under both the bylaw and the Wetlands Protection Act. And we know that the company has already started work. They've been excavating into the groundwater. We used a drone, which is something else. Nathaniel, you can use a drone to go and see what your neighbors are doing. It's legal. We have licensed pilots that have done it for us. And you can use these maps to delineate somebody else's wetlands and say to the Conservation Commission, as Janet mentioned, without hiring an expert will of course make your case better, but here's the state's own maps. Here's a drone showing that it's in 100 feet, 35 feet, whatever it is. So that's what we have done. And it'll really be a test of the current Conservation Commission to see whether they will step up and enforce the bylaw. This is a very, very significant project in a globally rare coastal plain pine barren forest and reservoir, etc. So it'll be a good opportunity to see how things go with the new commission. Thanks. Yeah, yes, it's all on Zoom. Yeah, there are a number of agenda items. Ours is on at 7:40. Our expert will make a presentation. I'll give an overview. And hopefully, as Janet mentioned, it will encourage people to use this law and use the process to step up and, do what you can if you're interested in enforcing our laws. Hi. Okay.
This,
Someone asked if we could identify ourselves.
oh, I'm Jerry Williams. This thing that you're bringing in, is it a Plymouth bylaw or is it a the department? DPW, not DPW, DEP,
Right.
DEP.
Yeah.
It's
right.
under both.
Yeah.
Now, if they decide to postpone it for 30 days and then they're under the old laws, are you still covered?
Yes.
Great.
Yes. Yeah.
Great.
And I
Postponing things for 30 days.
yeah, no, we already filed it under the current bylaws, so they can't, that applied at the time that we filed it, which was in June. And I will opine on the revocation of the regulations reported, right? Reported, right. In my view, based on what I've seen so far, that was not a public hearing. So that vote really had no effect. They did not revoke the regulations because they did not conduct a public hearing. It was not noticed as a public hearing. It was not opened as a public hearing.
Yeah, Meg, you're gonna have a hard time with that.
The
because
agenda states that it was a discussion and the chair did not say, I am opening a public hearing. That's my opinion. I'm sure others will
No.
have a
You
different
can-
approach, but that's what I've seen so far.
Get a copy of the recording from Michelle.
I was there, so
I know,
and I
but
will get
get
a
a copy
recording.
of the recording to use as evidence.
And who's talking?
This is Bruce Howard.
Oh, okay. All right, thanks. Anyway, any
But
other
you're gonna need to,
questions?
you're gonna need to take that to court.
Well, it's my view that the old regulations and the new regulations didn't change all that much, and that we still have our bylaw and we should be stepping up to enforce the bylaw, regardless of what the regulations say. You might have a different view.
Sorry, I haven't looked into this issue in any detail to render an opinion.
Okay.
So sorry.
I would encourage everyone to read the regulations that will go back into effect. Because Meg, you're right, there's a lot in those regulations. I don't think the commission has a good understanding of what they agreed to put back in place. So a lot of what was in the new regulations is in the old regulations.
That's my understanding as well.
Yep.
Any other questions, comments? Yeah. I'll just say.
I do.
that-
I actually have a question.
One-
Yeah. Just, sorry, I'm in a cafe. Did you say, so the specific things that the chairman objected to are also included in the previously extant regulations?
I believe that's a question for Bruce Howard.
Yeah, I would be not inclined to answer that because I'm not sure I understand what Randy is asking for. But
Yeah,
I
fair
mean,
enough.
we could analyze it further. I think some of the things that he objected to are in the rules and regs that they reverted to.
Thank you.
Well, thank you everyone for coming. If you wouldn't mind signing our sign-in sheet, just so we can stay connected if you wish. And thanks to everyone online for your attention and for joining. And I hope we can all stay connected.